Could I have your attention? It's time to get in your seats. Please. We're running a little bit behind time because of the swearing in of the two new members, but we're going to get started, and I'm going to ask Representative Setzler if he'll pray us in.
Dear Heavenly Father, we thank you so much for all the blessings you give us in our lives. We thank you that we can gather here today, Lord, to do your work. I just pray that our hearts will be fixed on you, not on our own ends or our own desires, but to your will and your will. We thank you for the blessings you give us in our lives. I pray that we would give you thanks for that, not just in our prayer times, but throughout the day. Thank you, pray that you bless us today. Pray your son.
Thank you. Well, good morning.
Good morning.
We'll get started. Mr. Powell. Excuse me, Mr. Dixon.
Mr. Chairman, I bring to you House Bill 125. The sole purpose of it is to extend the life of the Agriculture Education Advisory Commission, which has been in existence now for 5 or 6 years. Without this bill, it would sunset at the end of this year. I'd be glad to answer any questions that you might have.
Do we have questions? No questions. Thank you.
Thank you.
Representative Powell.
Thank you, Mr. Chairman. The committee, I bring to you House Bill 165 by committee substitute. This bill clarifies some problems. This bill has been around for a couple of years, passed the Senate a few times and got held up because of time restraints. There's a problem that exists, and nobody can explain how long this statute's been on the books. Public housing authority properties, there is a prohibition about any licensed alcohol dealer for open containers, on-premise sales being within 100 yards of these type of properties. Now, currently, you can put a package store next to these housing authority properties, but not on-premise sales. What this does is allows your city and county governments to issue an exemption if they deem that that'd be necessary.
Questions?
No questions.
Thank you.
Thank you, Mr. Chairman.
Alan. Wait a minute.
Mr. Chairman?
Yes, sir.
If this comes to the floor, is this going to be an open position?
I doubt very seriously. That's good that you can. Okay. Mr. McKillop.
Thank you, Mr. Chairman. I bring before the committee two bills this morning. First, House Bill 129, which would prevent developers from attaching a fee on the transfer of real property. It is a preemptive matter. There are some unscrupulous developers throughout the country who are adding fees for 99 years to the transfer of property that would inhibit the transferability of property. It's a simple bill that prohibits that fee and then carves out homeowners associations to allow those fees that are used for legitimate purposes. I'm happy to take any questions on that bill.
You did good. No questions.
And then also, Mr. Chairman, I'd like to ask for House Bill 71. I thought, as well as the first bicycle bill did on the floor, it was probably about time to bring that back. I would like to point out that it's supported by seniors, and cities and counties, I believe, would allow folks to ride on sidewalks. Sometimes it's local control on sidewalks and only rural sidewalks.
No more debate on that one. Next one.
Thank you. I appreciate the consideration.
I don't care. Mr. Clark.
Thank you, Mr. Chairman and committee. Bring to you substitute for HB 227 LC3 4030S. It's a simple bill that just fixes a loophole in a bill that was passed a couple years ago, allowing a child to administer an EpiPen to save a child's life and anaphylactic shock. In other words, they could die. And this, there was just two small problems, and that is that a child who may be carrying the EpiPen may not be able to self-administer due to being in shock. So this bill would allow the school personnel to be able to save the child's life. And secondly, it would allow for a child who was to have a first-time deathly allergic reaction, like happens in the half of the deaths that occurred due to bee stings, that you could administer the EpiPen, save the child's life. That is all. Just a bill to save children's lives, and I ask for your respectful consideration.
Do we have questions? Yeah. Hello, good morning. Okay, that's it.
Thank you.
Ms. Purcell?
Good morning, Mr. Chairman.
I get it from both sides, don't I?
I'm here on two bills this morning. Of course, the one that was yesterday, at 161, I respectfully ask for it to get on the calendar. Also, I wanted to bring to your attention House Bill 162, which is a bill to clarify the legislation that was passed last year on House Bill 571 to do with the sex offenders registration. It just so happened that when it was passed, we had a problem with it being illegal for anyone to take a picture, a photograph of any minor. And we're trying to correct that so that this particular legislation for sex offenders registry will not be served as unconstitutional. So we would be adding the definition for an individual, changing it to make it clear that the code applied only to the registered sex offender. And with that, Mr. Chairman, I would like to request consideration for it to be placed on our calendar.
This is questioning 162, so if you've got questions on 162, now's the time. All right, do 161.
161 is in regards to motorcyclists and those that ride motorcycles are unable to trip the sensors at red lights. Therefore, if they're making a left turn or they're wanting to go through, because of the weight of the bike or the metal on the bike, it will not trip those sensors. So we're trying to get it so with caution after 60 seconds with feet on the ground that you're able to proceed through that red light. If there should be an accident with an approaching car, you as a motorcyclist would be at fault, not the driver of that car. So it's with caution and with respect for other vehicles.
Questions?
Thank you, Mr. Chairman. Thank you for the bill. I do have a question, and it goes to tripping sensors at lights. And in some communities, I know that there is actually a button that you can push to trip the sensor to turn the light. Has that been considered?
Well, it's quite hard to get off of a motorcycle and walk over to push that button and then get back on your bike and proceed through the light. So right now what is
So like a remote trip is what I was thinking of.
They don't have those in South Georgia. and I ride a bike, so I know what goes on in regards to that. So, but thanks for the question.
They'll do those with garage door openers. Vice Chair.
Thank you, Mr. Chairman. Madam Chair, thank you, first of all, for bringing House Bill 162. That's a necessary fix on the sex offender reform that we did last year. I know you've been working with the Attorney General's office and the prosecutors on that, and thank you for taking that on and helping us with it. On House Bill 161, a concern has arisen on the insurance aspects of the bill. I understand in legislation that you wouldn't be charged, the individual who makes that left turn into that intersection would not be charged with, the applicable violation under Title 40. But the concern comes in that if they pull out of the intersection, a collision occurs, who's on the line for the inevitable medical damages that'll go along with it?
In our mind, it would be the motorcyclist that would be the one in the wrong for proceeding without caution.
The concern is that, while they wouldn't be cited for a violation of Title 40, they'll go ahead and, from a liability standpoint, point to the law in terms of, well, state law allows me to do this. It could be complicating with regard to at fault. I would just ask you to think about it, and then maybe there's a way to cure some of those concerns. But that concern is out there. It may be well-founded, it may not be, but it's something certainly to consider.
Well, and I agree with you. The other concern that I would have as a motorcyclist is the fact that if I'm in a turn lane to make a right turn and I can't trip that sensor, then what am I to do? I have to run that red light or either try to push the bike over to the side of the road. And if you've got 2 or 3 lanes of traffic, it's very hard to proceed across. So who's going to be liable there for me to get across so I can turn down a side road to back and turn a heavy bike and get back out to a red light so I can at least go through it. The problem that we also have in regards to that is at night, that if you're at a traffic signal and you cannot get that sensor to activate so you can make a turn or either go through the red light, a lot of times you motion for a vehicle behind you to come up to the side and hopefully they will trip those lights. They're afraid of us just like we're afraid of them for fear, are we being set up kind of thing. So there is a tremendous problem with motorcycles not being able to get through a traffic signal. And we've got about 40,000 traffic lights that we have big problems with across the state. This may be a less expensive way to take care of it.
No, thank you.
Mr. Bearden.
Madam Chair, I may have misunderstood the question that was just asked, but isn't it true, though, if the motorcycle turns left in front of the vehicle causes an accident, they would still be charged for that accident and still be liable for the insurance?
That's correct, and that's the way the bill is written.
Correct. And also, isn't it also true there's approximately about 40,000 of these sensors throughout the state that do not allow to be tripped with these motorcycles?
That's correct.
Thank you, ma'am.
Thank you.
Mr. Whip.
To the question presented by the Vice Chairman of the committee, is it not true that that basically with this bill, it's going to the motorcyclist is going to be treated as if he was at a stop sign with a through street in front of him. So it's really not any real difference in terms of his duty to protect the right-of-way that the drivers on the through street already have. So that really shouldn't change any liability issues. It's just that the stop light is going to be treated like a stop sign for the motorcyclist after a minute. He's still going to have to wait for a clear path before he can turn.
Any other questions? Thank you.
Thank you.
Mr. Jacobs.
Good morning, Mr. Chairman, members of the Rules Committee. I've come today to ask for House Bill 64. It's the third bill down under the modified open rule. What the bill does is amends the code section that deals with attorneys' fees in contract cases to allow for a determination of reasonableness of the attorney's fees in scenarios where you would have a high amount of attorney's fees. Right now, the statute says that when you take the principal amount, it involves a percentage or a couple of percentages. It says that you take the principal amount of the debt and you apply 15%, if the contract does not spell out the amount of attorney's fees or the way that the attorney's fees are to be calculated, then you apply these percentages, and the percentages are 15% of the first $500 and 10% of any amount above and beyond that. Well, let's just take 10% to make this easy. Say you have a promissory note in the amount of $2 million, a high principal amount promissory note. That would result in $200,000 in attorney's fees for a case that does not cost nearly that much to bring through the system. A couple of lawyers who serve in the General Assembly have actually encountered this scenario in practice, and I actually brought with me an example of a reported case where the application of the percentages has resulted in an obscene amount of attorney's fees. There's a reported 11th Circuit case where the amount of attorney's fees that resulted from applying the percentages 13111 resulted in $637,058.22 in attorney's fees. And the 11th Circuit said, although we agree with the district court that 13111 entitles the plaintiff to grossly excessive attorney's fees, we have no choice but to follow the statutory dictates of the statute. What the bill says is that if applying the percentages to the principal amount, the amount of attorney's fees that would result exceeds $10,000, the party that would be charged with paying the attorney's fees can apply to the court for a determination of reasonableness, meaning that the party that wants the attorney's fees would have to submit their bills, and the court would make a determination as to what it actually cost to bring the case, and that would be the award rather than applying the percentages. That is all the bill does.
That's all the bill does.
That's all the bill. It's a simple little bill, Mr. Chairman.
Ms. Smith, please.
Mr. Chairman, I am just impressed that you could do that with no sleep after that baby was born.
I'm a little shocked myself, Madam Chair.
Thank you. Can you speak to the retroactive nature of this? I mean, does this apply to contracts that were entered into possibly 20 years ago?
No, it will not. If you look at Section 2, it only applies to 13111 is actually a substantive part of any contract that's entered into as of the date that the contract is entered into. So what the bill says is that it only applies to contracts that are entered into, that are executed after the effective date of the bill, which is July 1.
So all notes in existence prior hereto that have the standard language of reasonableness, that they will be adjudged on the prior basis?
That's correct.
Okay, thank you.
Mr. Whip.
Just to boil the bill down, all this bill does is keep lawyers from getting paid more than they deserve.
And I assume that would be an adequate presentation on the House floor?
I think that'll get you 180 votes.
I move.
Any other questions? Mr. Secretary.
Got a lot of feedback up here. Representative Jacobs, on line 36 and 37 of page 2 of the bill, if the amount is less than $10,000, do we go back to that 15% on page 1? Is that
That's right. Then the percentages would apply. So you have to apply the percentages, and if the percentages would result in a total amount of attorney's fees higher than $10,000, that's where you get the right to then have a determination of reasonableness.
Was there any discussion about a possible conflict of interest with lawyers and judiciary setting a reasonable attorney fee?
No.
You've got no other questions. Thank you.
Thank you, Mr. Chairman.
Well, no, I'm not. Mr. Burns? Would you enlighten us one more time?
Yes, sir, Mr. Chairman. Good morning, members. I'm here again to ask for House Bill 179. It's the outdoor advertising bill that allows for some rewrite on the, excuse me, allows for some changes in the law in that area, and we're also asking for an amendment that would make the bill a revenue-neutral bill as far as the cost of Georgia taxpayers, and that is 0475. I just ran over from DNR, so I'm a little out of breath at my age. Mr. Chairman, that's what I'd like to ask for. For any further explanation, I'd be glad to give it if the members desire.
Are there any questions? And keep in mind, we've hashed this thing out plenty in this committee the other day, so do I hear any questions? Thank you, Mr. Burns.
Thank you, Mr. Chairman.
Mr. Parsons.
Thank you, Chairman. Ladies and gentlemen of the Rules Committee. I have House Bill 116, which is on, well, it's on page 1. I think it's the only page. It's under Modified Open Rule. And this bill would allow local exchange carriers, your local telephone companies, to make financial transactions, interstate financial transactions, without the approval of the PSC. This is something that's we're only one of about 6 states that still does that. It's kind of an antiquated statute. In today's time, these transactions need to be made quickly, and the PSC, they really don't have the staff to do it, or really the expertise to do it anymore anyway, to do the overview. So just updating the code to a more current language would allow faster transactions to react more quickly to the markets.
Mr. Vice Chair.
Chairman Parsons, just a clarifying question. I know that as part of the telecom deregulation back in 1995, we have some telecommunication entities that are under the Public Service Commission's jurisdiction and some are not. These local exchange companies are currently still under the PSC's jurisdiction with regard, under their jurisdiction in general. Is that a correct statement?
Some of them are.
Okay. Are they under their jurisdiction for purposes of rate making?
In some cases they are, right.
Are the if I can just have one follow-up, Mr. Chairman, are the transactions that we're talking about here, are those otherwise included in the rates that they submit to the Public Service Commission for approval? In other words, is this part of their overall rate that they get approved by the PSC? The pricing structure.
Yeah, I appreciate the question. I'm not sure if I understand exactly what you're asking.
In other words, the costs, let me clarify, the costs of these transactions, I assume, are part of the rate or the price that they would submit, assuming that they do, to the Public Service Commission for approval, and so therefore it relates to the Commission's ability to regulate them as per current law. Is that a correct statement?
I think that's right. I mean, I'm still not exactly sure, but yeah, what we're talking about is as far as financing, to finance new equipment and capital improvements, things like that. Okay. So, to what extent that is actually under what you're asking about, I'm not really sure.
Okay, thank you. I appreciate it. We'll find out. Thank you.
Any other questions? Mr. Leader.
Just, Chairman Parsons, thank you. Just to conclude on that line of thought, I guess, do do you feel like that there's a possible unintended consequence in here that one of these companies could arrange a borrowing with say, a closely held other company in another state at an interest rate that would be part of their rate structure cost, and in that way sort of maybe game the oversight system a little bit? Is that a possibility?
I don't see it as I mean, I guess anything's a possibility. I don't see it as anything that's likely. I mean, there's a couple of things I would say here. First of all, the PSC, as we all know, constantly they're underfunded. I mean, they would tell you that. I believe it's true, and we literally cannot provide them the funds they need for the staff that they need to do everything that they're tasked to do. They literally don't have the personnel to oversee all these transactions, and they really don't have the expertise. The companies themselves, I mean, they're in the business to provide the service for the customers. They're in business to provide that service, and they want to stay in business. I think it was my view and the view of the committee that they have more expertise in making these financial transactions than what the PSC would be able to provide as an oversight. I don't know. I'm sorry if that may not really address your question, but I mean, I would say anything's possible. I don't think that's likely at all. I don't see any likelihood of it.
Any other questions? Thank you, Mr. Parsons.
All right, thank you.
Mr. Benton.
Thank you, Mr. Chairman. I want to call the committee's attention again to House Bill 126. That would recognize April 19th as Patriots Day. That is in honor of the shots heard around the world at Lexington and Concord, also an event that occurred here in Georgia on that date as well during the American Revolution. Thank you, Mr. Chairman.
Any questions?
Oh, it's also Mr. Hannah's birthday, so we'll include that as an amendment there.
Patriot.
Okay. Any other member of the committee? Mr. Roberts.
House Bill 137, I know Representative Sheldon couldn't be here today, but that's the department's bill as far as GDOT, just their little housekeeping bill.
Okay. Mr. Vice Chair.
Chairman, House Bill 238 is the reform of the governance structure of our indigent defense agency at the state level. We have a situation there where we've had a lack of definition in terms of straight line management, who's accountable for what responsibilities to the agency, and as a result we've had some problems in just the sheer operation of the agency itself. This establishes straight line management, accountabilities, responsibilities. If we can get over this governance issue with our defense agency, then perhaps we can tackle the issue of funding adequacy. It has the support of the State Bar, ACCG, and various circuit public defenders around the state. Ask for the committee's favorable consideration.
Anyone else? Okay, we'll set the calendar. HB 193 under the modified structure. Do I hear move? Move. Any opposed? HB 194 under modified structure. Any opposed? HB 126 under modified structure. Any opposition? HB 179 as amended. Any opposition there? to the author, was the amendment adopted yesterday? Well, okay. I'm going to go with... okay. Mr. Vice Chair.
Thank you, Chairman. I'd like to go ahead and ask that pursuant to Rule 33.3 of the House, that debate on House Bill 179 be limited to 2 hours, and the time for the total consideration of the bill limited to 2 hours, time to be allocated at the discretion of the Speaker.
I'll accept that as a move. Any opposition to that? Okay, the motion carries. That means... Okay, since there was an objection, I'm sorry I missed it. All in favor signify by aye.
Aye.
Any opposed? The ayes have it. That's it.